Welcome to International Legal Scholars and Practitioners, the podcast where we explore the intricate world of law with leading experts and practitioners. I'm your host, Dr.Mokhinur, and today we have the privilege of delving into the dynamic realm of commercial litigation and arbitration with a distinguished guest from the United Kingdom. Joining us is an attorney, Jenna Kruger, a seasoned legal professional and partner at Eldwick Law Firm, where they specialize in navigating the complexities of commercial litigation and arbitration. In today's episode, we will explore the nuances of commercial litigation and arbitration, discussing recent trends and notable cases and invaluable lessons learned throughout the Jenna Kruger's distinguished career. Welcome, dear Jenna. We're glad to see you here today, and many thanks for agreeing to interview and sharing your practice.
Thank you so much for inviting me, and it's a real privilege to be here. So thank you very much.
Thank you very much. And with your permission, let us start the discussion. I want to ask about the realm of United Kingdom procedural law, about recent developments or changes in court rules have had a significant impact on litigation strategies and case management.
So in the UK, one of the main focuses on the courts have at the moment is on reducing the costs of litigation and bringing cases to trial in a lot more efficient and in a quicker procedure. So there's been a lot of recent adaptations to the civil procedure rules which focus on costs and which try and reduce costs for parties, particularly in lower value claims. So recently in the UK, we have what's known as a cost budgeting procedure, where we fill out a specific form and we set out what the costs are going to be for each phase of a proceeding. So for example, we'll go through and we'll say we estimate our costs are going to be this amount for witness statements, this amount for trial, this amount for disclosure. So the court brought that into effect about 10 years ago, and they're starting to review that this year. So what they're trying to do is they've acknowledged that it's very useful to have this cost budgeting procedure because it prevents circumstances in which legal fees are basically exceeding the actual value of the claim. So it allows the court to supervise the legal fees that are being incurred. And they've reviewed that and they said that it is beneficial to have this cost budgeting procedure, but that they've realized that it needs to be more dynamic. They need to be able to tailor it to different types of cases that are ongoing. So for example, there may be cases that are between 100,000 and £1 million that require a little bit more of a light touch from the courts. It's not the case that the court needs to monitor every single procedure, and that can be more of a light touch, whereas cases that maybe exceed $1 million require more stringent budgeting procedures because it's likely that those costs could get out of control. Like another recent developments is the courts are embracing technology, and the way in which they're doing that is the disclosure procedure. So in the UK, parties have to disclose and share any documents with the other side that are either helpful or unhelpful to their case. In the UK, they introduced a new practice which encourages parties to use technology in that procedure. So they used e-disclosure where there's, for example, cases that deal with facts that are 10 to 12 years running. There's going to be a large amount of documents, and they encourage litigants to kind of use e-disclosure, which uses keywords. And you upload it into the platform and use keywords, and that will bring out relevant documents. And what that prevents is, for example, one party just delivering thousands and thousands and thousands of documents to the other side. And that just cost builds, and in the hope that they basically not going to find relevant documents just because there's too many to review. So those are kind of the two main recent developments that have happened in UK procedural law that go to reducing costs and kind of adopting a more efficient procedure to get to trial.
Thank you. It's very interesting. And could you provide insights into the key differences between the commercial litigation practices in England and Wales compared to Scotland, and how these differences shape legal practice?
Yeah, so I don't practice in Scotland, but I do know a couple of differences between the two procedures. So one of them is that one of the main differences in the procedure is that in England and Wales, the limitation, so the time in which a claim will be barred from being, you'll be prevented from bringing the claim is 6 years in England and Wales, whereas it is 5 years in Scotland. And another key difference is what's known as what procedure solicitors have to undergo before launching a claim. So in England and Wales, it's called the pre-action protocol, which encourages parties to write letters to each other where they set out their claim and they wait for a response in the hopes that a claim may be settled without going to court. So before you go and you issue a claim in the High Court in England and Wales, you need to engage with the other side, set out what your claim will be in a letter and wait for them to respond and see if you can reduce the issues and disputes and potentially reach a settlement. Now, I understand in Scotland that is encouraged, but there's not a specific procedure that has to be that they have to take before issuing a claim. I also think that there's differences between disclosure in England and Wales and Scotland. In England and Wales, again, the parties are encouraged to disclose all documents at early stages in the proceedings, whereas I understand in Scotland it's a little bit more difficult. So I don't practice in Scotland, but I do know that there's a couple of key differences between the procedural system in Scotland and the one in England and Wales. So in the main key difference is the time in which a party has to issue a claim. So in England and Wales, it's 6 years. So from the date on which the action accrued, a party has 6 years to then issue a claim. Whereas in Scotland, I understand that it's 5 years. Another key difference is the procedure that practitioners have to follow before issuing a claim. So in England and Wales, solicitors and parties have to follow what's known as the pre-action protocol. And this encourages litigants and parties to basically write letters to the other side where they set out what their claim will be, how much they're claiming, and provide any documents in support of their claim. And the other side then has an opportunity to respond. And the purpose of this is to hopefully try and reduce any matters that may be in disputes and to even try and settle the dispute without issuing a claim. So in England and Wales, you are required to follow that pre-action protocol. There are cost sanctions if you don't. And I understand in Scotland, although it's encouraged, there's no formal procedure that has to be followed. I think the third main difference procedurally is that is in relation to disclosure. So in England and Wales, parties are encouraged to provide copies of any documents that they will rely on before issuing the claim or at the time of issuing the claim, whereas disclosure is a bit more difficult in Scotland, and that parties aren't necessarily under an obligation at the outset, and there may have to be specific applications made. So those are the key differences.
Okay, thank you. And how do the UK courts approach case management, and what tools or mechanisms are in place to ensure efficient and timely resolution of disputes?
Yeah, so the courts encourage parties to try get to trial as quickly as possible and as cost efficiently as possible. And in England and Wales, there's a specific hearing which deals with that. So after the parties have pleaded their cases, we go to what's known as a cost and case management hearing, where the parties go before a judge and they set out directions. So they basically, there's a time frame leading up to trial, which the parties have to comply with. By this date, you'll do disclosure, by this date, you'll do witness evidence, and then about a year later, you'll be going to trial. So that's the way in which the court kind of monitors and ensures that a party that issues a claim proceeds and actually prosecutes that claim as quickly as possible, and a defendant engages. Otherwise, there's cost consequences, and there's sanctions for not complying with those directions. So it's almost like a timetable monitored by the court that the parties have to comply with. In terms of cost efficiency, as I said in the beginning, there's like budgeting, where parties have to submit budgets and they state what they anticipate the cost will be, that the court then has, the court will either approve or reduce. Then there's also obviously technology. The courts encourage the parties to use technology where it will reduce costs. This could include the e-disclosure platform that I mentioned earlier on. And generally the parties are always kind of under an obligation to work effectively with each other to ensure that the claim is brought to trial and before a judge as soon as possible.
Okay, it's very interesting. And in light of technology advancements, how are the UK courts adapting to e-filing, virtual hearings, and other digital innovations? What challenges and opportunities do these pose for practitioners?
So one of the main recent procedural updates is following COVID. So during COVID, there was the lockdown and parties couldn't attend hearings. And during this process, the courts allowed for virtual hearings where you attend hearings via Teams. And even though we're out of the lockdown now, that is still ongoing. So wherever there's a hearing that is likely to last less than half a day, that hearing will take place virtually. And this then reduces the costs of, the time taken to travel to court, and also allows the courts to hear more hearings during a day. And we do have an e-filing system in England and Wales where everything's kind of uploaded onto an e-filing system, and it basically allows the court to deal with sometimes some of our filings on the same day. So that's quite a quick and efficient procedure.
Okay, thank you for your answer. And when it comes to the enforcement of judgments, what are the crucial considerations for legal professionals navigating the intricacies of cross-border enforcement in the United Kingdom?
So in the UK, we often deal with cases that have international elements, and one of the main considerations for our clients and parties is that it's all good and well getting a judgment, but how am I going to enforce that judgment? They want to obviously recover their money. So the main consideration is for practitioners to, first of all, identify where that person's assets are. Mm-hmm. So in which country those assets are, and then to have a look and see, is the judgment in England and Wales enforceable in that jurisdiction, and what procedure has to be undertaken. So from our side, we would obtain a judgment, and then we would likely work together with practitioners in other jurisdictions who can then apply to have that judgment recognized and enforced in that jurisdiction. When it comes to the other way around, the UK does recognize a lot of arbitration awards and orders in other countries, and it's a fairly quick procedure, you make an application in the UK for the court to basically recognize that judgment and issue an order on the same terms as that foreign judgment. The next kind of consideration that has to be taken into account is once you obtain that foreign judgment, what is the enforcement procedure? So, for example, when you have a party that may have assets in two different countries, one country may be able to put a charge on a property a lot quicker than the other. So you may choose to rather enforce in that jurisdiction as opposed to the other. And then, of course, most recently, what needs to be taken into consideration is sanctions. So this has obviously had a large impact in cases where companies or individuals hold assets in Russia. That's become increasingly difficult to enforce against.
And as we draw the curtains on this episode of international legal scholars and practitioners, a sincere thank you to our esteemed guest, Jenna Kruger, for sharing her profound insights into the intricate world of commercial litigation and arbitration. The legal landscape is undoubtedly complex, but Jenna Kruger's expertise has provided us with a compass to navigate through the challenges and opportunities that arise in the real world of business disputes. We are truly grateful for her time, knowledge, and the wealth of experience she had brought to the table today. And to our listeners, thank you for joining us on this enlightening journey. If you found value in today's discussion, be sure to subscribe, rate, and share this podcast. International Legal Scholars and Practitioners is committed to bringing you engaging conversations with legal luminaries. So stay tuned for more insights into the ever-evolving legal landscape. Remember, the law is not just a set of rules, it's a dynamic force shaping our society. Until next time, this is Dr. Mokhinur signing off from International Legal Scholars and Practitioners. Thank you. Bye.